The great galleries and museums of the world have long had on display treasures looted by empires and colonial powers of the past. But recently, the countries whose items were stolen are getting tough about retrieving them, and that sparked a series of legal battles. Liam Cochrane reports.
Near the corner of West 83rd in Amsterdam, federal agents from Homeland Security Investigations...
It sounds like something out of an Indiana Jones movie. But when US authorities broke into a Manhattan storage unit in late July, they discovered a stash of ancient statues thought to be worth $20 million.
As the agents swarmed this storage facility...
It's suspected these treasures were looted from temples in South Asia, destined for a New York art shop that supplies museums and galleries around the world. The Indian-born art dealer Subhash Kapoor has been extradited to India to face charges. Galleries around the world are scrambling to check their collections.
Well, we have 6 works in the collection we've discovered that were acquired from Subhash Kapoor. 3 sculptures and 2 paintings back in the 1990s, and 1 sculpture in 2004.
Investigations are still underway into the works at the Gallery of New South Wales and 21 others at the National Gallery of Australia. Because the works are in Australia, they're protected by various national laws and international conventions. But if they'd been on loan overseas when the scandal emerged, there's a chance they may have been seized. Borrowing art and antiquities is big business. There's the cultural benefit for visitors and the kudos of securing blockbuster shows.
The discovery all those years ago was a piece of history like no other, and is so precious has rarely left its country of origin.
It's really important for museums large and small in Australia to be able to borrow the best of the world's exhibitions and also to loan objects from all around the world. If we aren't able to do that, we're simply not going to be able to show people in Australia the best of what the world has to offer.
But borrowing valuable works of art is much like borrowing anything else. You only get to keep doing it if you gain a reputation for returning what you borrow. Australian Arts Minister Simon Crean has announced he will be putting forward a new law later this year to offer a kind of diplomatic immunity for works on loan to Australia.
Now, most countries in the world will not lend to a country that doesn't have a protection regime in place that will guarantee those loans are actually returned, that they aren't seized while they're here.
The biggest test case in Australia involved 2 Indigenous bark etchings on loan from the British Museum in 2004. Usually these artefacts would have been protected under Australian law, but a loophole in Victoria's state legislation allowed Aboriginal elders to claim ownership. The etchings were seized.
The world is watching what this state government does with the legislation they've got and how they're managing it and how they respect the rights of traditional owners.
After several federal court hearings, the bark etchings were returned to the British Museum and the legal loophole was later closed. Gary Murray thinks the immunity from seizure legislation being proposed now is a direct result of the bark etching controversy, and he's angry about the lack of Indigenous input.
I think that's a disgrace on the part of the Commonwealth and all the parties involved, including the museums that have put in submissions and who have Aboriginal advisory committees. Why weren't we told about it?
The government discussion paper released last year didn't receive any submissions from Indigenous groups. The feedback was almost entirely from galleries and museums.
I think it's very important that we do have a regime that does enable Indigenous material held outside Australia to come here. We need to be able to see many of these treasures that were, for all sorts of reasons, removed from Australia in the early days of settlement.
Gary Murray sees the issue as less complex.
Invent laws to return stuff. Don't invent laws that give comfort to people who've stolen stuff.
While the immunity from seizure legislation would apply only to visiting works, some see a link to wider issues of cultural ownership.
So I think what we're looking at here is a bigger discussion around the way in which objects move around the world and for what purposes. So they not only serve our national institutions and, say, regional institutions, but those objects are also part of a local story or Indigenous community, the work of Indigenous communities, or they could be part of other stories to do with war and atrocities.
The art world is particularly careful about dealing with works obtained during the Second World War. One proposal for Australia's immunity law is to include an exception for immunity, a so-called Nazi carve-out.
We'll see a parallel in relation to some other instances where objects have been looted during wartime. So in Pakistan, we'll see some stuff in relation to Cambodia.
Museums insist the immunity law would not be a tool for protecting dubious acquisitions.
The legislation doesn't help to protect stolen goods in any way, shape or form at all. Any goods that are known to be stolen simply wouldn't be brought here. Goods that were, for argument's sake, in Australia and found to be stolen would immediately be returned.
What Australia decides to do on this issue will be important for New Zealand, as touring shows often stop off in both countries. And the details of the proposed immunity from seizure law will be revealed in spring when the legislation is put before Parliament.